It was the third petition challenging a presidential election in Uganda. For all intents and purposes, historic. In 2001 and 2006, Dr. Kizza Besigye unsuccessfully challenged President Yoweri Museveni's legal team took turns today to punch holes into the petition. This time, though, former presidential candidate Amama Mbabazi, who was in Museveni's legal team on the two occasions, petitioned the Supreme Court to overturn the results of the February election and order a recount in 45 districts, including Kampala and Wakiso. For the first time in the country's history, a record 9 justices had a petition challenging a presidential election. 4 women and 5 men. Mbabazi's legal team secured an early significant gain. After a long and heated exchange with the justices, court allowed them to amend the petition and introduce 15 more grounds to the original 28. But Chief Justice Bart Katurebe scolded the lawyers, saying they seemed unprepared.
Now this is wasting time. First by ambushing each other, by ambushing court, wasting time that we don't have.
Then came the 9 Makerere law dons who applied to be enjoined in the petition as friends of court, or amicus curiae. It was another unprecedented move. And court granted their wish in a ruling read by Justice Lilian Tibatemwa. However, 8 NGOs and election observer groups, including SEDU, Chapter for Uganda, Transparency International Uganda, were not lucky, as their application to also be enjoined as friends of court was rejected. The petition rotated on the claim that the Electoral Commission, led by Dr. Badru Chigundu, cooked up figures to declare President Museveni as re-elected. So when he took to the witness stand to defend the institution, Chigundu spoke passionately.
Those you could have looked at.
Well, where agents were absent and they chose not to sign, and especially where agents were absent, there will be no such development.
May it please, my lords, I'm Jude Biamukama.
It was a moment for the lawyers to put their best foot forward, with many of them making their first appearances in a presidential petition. Lawyers Jude Biamukama of the petitioner and Ellison Karhanga of the Electoral Commission, the youngest of the lot, spoke passionately for their clients.
The petitioners in this court have been given a very unrealistic and heavy burden. Firstly, you'd like them to demonstrate non-compliance with the law. Secondly, you want them to show that the non-compliance is as widespread as possible. And thirdly, you want them to show that actually the widespread non-compliance has affected the results. Clearly, that burden cannot be met by any petitioner.
So you have a petition, my lords, which is totally and absolutely limited in scope, in extent, in substance. It is the sort of petition, my lord, that courts are pleased to dismiss.
Chief Justice Bart Katurebe's humorous one-liners were seen as icebreakers in an otherwise tense room clouded in legalese.
So there should still be numbers.
It doesn't matter if the respondents bring the numbers. We deal with them. Because look here, the respondents will always be...
I'm not looking there.
One of President Museveni's lawyers, Ebert Viencha, coined a phrase that would later be referred to by more of the respondents' lawyers to describe the nature of the petition.
Pray that this petition, which is completely without merit, unsupported by any evidence, based purely on hope, conducted by way of a fishing expedition, does not meet the standard required to set aside the election of the people of Uganda, of their president.
The petitioner's lawyers seemed to drop the ball on some occasions when they were forced to withdraw claims on grounds that they lacked adequate evidence to back them. For instance, Asman Basalirwa had trouble making the case that many Ugandans were disenfranchised after the Electoral Commission degazetted the 2011 voters register.
Before Dr. Chigundu came for examination, you had not prepared your own evidence to support your allegation that people were disenfranchised.
My lords, we had prepared it in part of the rejoinders that were actually rejected. That information was
the
there.
The rejoinders were not your primary case.
His colleague Severino Twinopsinje failed to provide evidence to back claims that there was a 100% voter turnout at some polling stations.
There is no evidence before you that anyone died at that polling station. There is no evidence before you that a registered voter came to you and said, I did not vote, but there was 100% at my polling station. This is all conjecture.
Now council comes here as usual and disowns the alleged document without any apology.
I'm sure the same media have heard you now.
Yes, that's why I'm raising.
I am sure the same media have heard him withdraw the metrics that he was trying to use. And I'm sure the same media have heard Mr. Chiochwan tell him it's a forgery.
But Mbabazi's lead counsel, Muhammad Mbabazi's calm and poise seemed to win many hearts, even when his ship appeared like it was sinking from the holes poked by the respondents' lawyers. Then there was a controversial break-in at two of Mbabazi's lawyers' offices on the eve of the hearing. The petitioners' lawyers claimed that many of their affidavits were stolen. The justices seemed unconvinced though. Mbabazi claimed that Chigundu relied on his own DR forms to declare results, but until the last day, the commission failed to deliver physical copies of these forms to the petitioner.
We asked them to give us some documents that relate to the BVVK, including the information relating to what information would ordinarily be found on that machine. My lord, they didn't.
Mr. Tumsime, in your letter you say they had taken some documents, and they have said they haven't. And I think earlier in the day you said actually it is true they haven't. We find that irregular because that's not the usual practice. So this is something I would like you to explain. What's the problem about giving them the documents which they inspected and which they want?
My lord, there's no problem at all. The evidence that I referred to of the agent not having more, even 50% of the agents, rather the petition not having 50% of the agents, is on record. That was...
Before we get to that,
yes.
Let's sort out the issue of the documents.
My lord...
The inspection was allowed.
Yes.
At the end of the inspection, from what I've seen, they wrote and said, can we have copies of these following documents? And you stated later, writing to the registrar, that they had taken copies. Now it appears that's not true. They didn't take any copies. So can you make available to them the copies they require?
Mbabazi's lawyers then applied for an adjournment to scrutinize the declaration of results forms. It was granted after a standoff amongst the lawyers. Shidan Wuchere, NTV.